with the legal teams. Journalists posed the questions to them as to whether they will be seeking reviews, and both sets of legal teams were quite clear. Their response was that they still have to study the contents or the full judgment from the apex court, after which a decision will be made. But Dr. Ernest Akon, who is lead counsel for Dr. Amanda Odoi, was quite clear when he mentioned that, of course, yes, a review will be sought, and that will determine their next line of action. But I must also add that he was quite confident that in the review process, they should be able to overturn this unanimous decision the court pronounced earlier today.
Very well. Thank you so much, Jude, and good job there. We'll come to you as and when there are updates. Thank you so much. Jude Mensah Duncan reporting from the Supreme Court, which has dismissed 2 suits challenging the constitutionality of the anti-LGBTQI bill. Now, Fred Tejabano is here with me in studio, and so we'll trace back a bit and then bring you events leading to this decision by the court. Fred, this bill and everything surrounded it started somewhere 2021.
Yes. So this thing started somewhere 2021, as you mentioned. It was
right. Fred, hold on for me. I understand Professor Techua is currently speaking to the media from the Supreme Court. So let's go back there and let's hear what she has to say.
First time that it passed the act was challenged. The Constitutional Court ruled against the act. It went back again. This time, they were not challenging the procedural issues. They were challenging the content of the act. Largely, the court let it stand, although it said that some of the provisions were not right. So I hope that our courts learn from each other. They take steps from each other. But we still, as a human rights defender and as somebody who believes in constitutionalism, I take what the Constitution says seriously about protecting the rights of all Ghanaians, about not discriminating against any Ghanaians, you know. So, but mind you, this action was not about the substantive provisions. It was procedural. Yes, so we preserve our rights. When we came to court last year for an injunction, one of the things that was being urged on us by the Chief Justice was, why don't you wait? We have invalidated acts, so wait, let the act be passed. But we thought, still, because the Constitution allows us to bring an action, even at that stage, that we would do that. Now that the Supreme Court says there's nothing wrong with that, it should proceed, we still have options under the act, you know.
But how hopeful are you? Because there are people who have suggested that, I mean, this is a country where 93% of the population have already made it clear that they don't want to have LGBTQ people as their neighbors.
So what are they going to...
Don't you reckon this is a fruitless course?
No, I don't reckon that it is a fruitless course. What you are telling us is that we must legislate intolerance into law. That is a dangerous way to go, because the next time they might say that they don't want burly men like you. And because a majoritarian rule or a democracy does not mean just the wishes of the majority. It is also about protecting minorities. So the fact that you do not want an LGBT person as your neighbor does not mean that you're going to send somebody to jail just because the person says that they are gay or lesbian, and then we must pay for their upkeep. No, that is not right. So I do not think that, you know, I think that if we were to take the position that, oh, it is fruitless, then we will really be legitimating tyranny, dictatorship, etc. You know, last year in Kenya, or earlier this year in Kenya, there was a law about registering organizations, and some LGBT organizations filed to be registered. The Supreme Court decided that even if they have the equivalent of a Section 104 of the Criminal Offences Act in their criminal code, that is an action. But the freedom of association allows even LGBT organizations to be registered. They are not compelling anybody to join them. If you have a club, you are open to your members, right? So this is them. Stay away from them. If you see them engaging in any activities that are against the law, go after them. I think that we need to sort out some things. We confuse pedophilia, a whole lot of things. Pedophilia is a crime. Whoever commits pedophilia, whether they are heterosexual, homosexual, they offend against children. The law should deal with them. Our marriage law talks about marriage between men and women, right? Yeah. Fine. So no two men have gone ahead to say that they should be married. But to say that I cannot defend the right of LGBT persons, you are imposing on my freedom.
How do you respond to the criticism that these sexual minority groups are not necessarily under attack in Ghana because we have very few cases of the attack?
Have you seen footage of them being banished from traditional areas, of being dragged to chiefs' palaces, and of sheep and other things being cut and poured on their heads? When you banish somebody, when you say that you can no longer live here, that is not an attack. When people extort money from people, when they threaten that they will reveal your identity, that is not attack. What do you understand by attack? I think that there have been enough documented cases of attacks, even without a law in effect. And this is going to embolden all kinds of people, including criminals and hooligans, from taking the law into their own hands. If LGBT people offend the law, deal with them. But to single out a group of people because you don't like their sexual or gender identity, that is what I find abhorrent.
So what are the next steps for you and the entire...
We will wait. The president assents to the bill. What will be your next line of action?
Yeah, so we will wait for the judgment on Friday, as the court has promised. We will wait to see what the president will do. We will advise ourselves. We are not going to stop defending people because there is a law which says we cannot do that.
Are you paying a price for what you're doing? Because
personally, no. I don't think that my reputation has suffered. I do not believe that my family thinks any the less of me, that my friends think any the less of me. No.
I'm speaking in terms of probably attacks or threats to your
security concerns.
Oh, I'm fine. Some people have made threats, but I'm not afraid. I think that as a prudent person, I should know where I would not be welcome, But I actually think that many of us are fearful people to even bring up such things. Okay. And I hope the media will play its role by reading what's in the bill, which would put some of you also under attack, even for reporting issues. How can you have a law which says that even calling for the repeal of that law is an offense? Please read the bill. Thank you.
Wow. So, Nanatu, for Professor Techiwa Menu just engaging the media, she's made a point clear that it's important that this bill be set aside. Now, she made the argument that she represents Dr. Amanda Odoi. She's part of the team of Dr. Amanda Odoi who brought this matter before the Supreme Court. She made it clear that there's a petition specifically targeting the constitutionality of this bill, whereas the other one brought before it by Richard Delaskai seeks to look at the human rights aspects of the bill. Now, she makes the point that if you go through the bill, there are several infringements on the Constitution. There are several infringements on the Constitution and also infringes on human rights. For each reason, looks at this matter again and sets aside a bill. Question was also posed to her. She made it clear that the legal team will be meeting to put forward their next line of action. She's also already made it clear that they'll be seeking a review of this particular case. So, Nana, Professor Techiwa Menu, you just heard. Prior to that, we also heard counsel for Richard Delaskai, Pakwesi Abedu, also speak to the media, where he also made it clear that they still have to look through the full judgment from the Supreme Court, the full reasons for the Supreme Court's judgment, and they would, based on that, determine their next line of action.
All right, thank you so much, Jude, bringing us that interview there with Professor Techiwa Menu. She is a Ghanaian academic, a professor of African Studies at the University of Ghana, Legon, and one of the main opposers to this anti-LGBTQI bill. Earlier, Jude, together with a number of media men, spoke to counsel for Richard Delaskai, Pakwesi Abedu. We want to hear what he had to say in response to the decision by the Supreme Court.
Bear in mind that it was a seven-member panel. That's one thing we must bear in mind. A 7-member panel. And going for a review will mean an additional judges. And the question we should ask ourselves is, would that make any difference? So we are yet to advise ourselves on that.
So from the word go, you will be against seeking a review?
As I said, lead me not into temptation. I've not as yet seen the full reasoning of the court. Who am I to come openly on what next step I'm taking? I believe it is not proper. So please, let's all abide with the timetable of the court. They said latest by this Friday, we'll have the full ruling.
As my colleague said, one thing is certain is that they say it was premature. And on the other hand, the president said all that long that he wanted to wait for the Supreme Court to pronounce itself before signing the bill. Don't you see, isn't it like issue shaker?
You may recall that we filed an application for interlocutory injunction together with our rates. And the Supreme Court indicated that its ruling on that application will be determined together with the rates. We have not as yet seen their pronouncement on that. So please, based upon the content of the judgment, we will know the next step to take. For now, we are not in the position to tell us what next we are doing.
Very well. Counsel for Richard De La Sky speaking there, lawyer Pakwesi Abedu. Now, counsel for Dr. Amanda Odoi has also been speaking. Recall that Dr. Amanda Odoi had earlier sought an interlocutory injunction restraining Parliament from transmitting the bill to the President for assent or otherwise. So let's listen to counsel for Dr. Amanda Odoi as well on their response to the decision by the court.
Well, we disagree with the court decision. We respect the decision they have given, but we disagree with it. We are yet to have the full record, which the court has indicated it to produce on Friday. So when we get it, we'll study it and we'll know our next line of action. So for now, we aren't saying much. I know some people are talking about review and all that, but we have to see the record first.
Should the president go ahead to sign this bill into law, what will be your team's, next line of action again, if I may ask?
We wait to see if the president will sign. But the record, like I said, is yet to come out on Friday. And so when we have the record and we consult with our clients, then we'll see the next line of action. And before then, anything can happen.
What is clear is that the decision of the Supreme Court put finality to whether the president should sign or not. Parliament can go ahead and then transfer the bill to the presidency for the president to sign. Does it affect the future line of your action? Should you read the reasons and things that you have?
So yes, the decision of the Supreme Court is final, but this is not final. There is another leg of finality to go. There is a review jurisdiction of the Supreme Court, which is available to us if we want to use it. And so it's not final yet. It doesn't matter. It doesn't matter. There have been instances where there have been a 5-0 and an appeal. On a review, it has been overturned. So anything can happen. And we have to... that's a review. So we wait to see. So it depends on what is in there in the judgment. And then we can advise ourselves.
You must also remember that this was an interlocutory application, that we were proceeding on procedural grounds, so we still have options. Yes, but we have said we will wait to hear to see what is in the judgment.
But when you say options, what exactly are you referring to?
Well, we did not go to court on the contents, on the provisions of the bill. We were proceeding on Article 108, that this is a private member's bill, and based on that, certain procedures needed to be followed. So we want to see what the judgment is and what the arguments have been made concerning what we raised in the application.
And how earlier we expected to hear from you?
Well, we will hear from the court on Friday. We will take our time to study it. We will consult with our client, and we will decide what our next steps will be.
Thank you so much.
You have been following the case right from day one. Are you surprised in any way that this is?
Yes, I am surprised. Yes, and disappointed.
Disappointed?
Yes.
Okay. We've been hearing Dr. Amanda Odoi. Where is she?
She's not in the jurisdiction. Yes.
But we hear you may we, so we wanted to clarify that.
No, we are talking about the lawyers. We are not talking about the plaintiff. Yes.
All right, you heard from Ernest Akon, lead counsel for Dr. Amanda Odoi, and then subsequently from Professor Techua Menu, speaking there regarding the decision by the Supreme Court to dismiss the two suits challenging the constitutionality of the anti-LGBTQI bill. Now, as we established earlier, processes leading to the passage of the bill started somewhere 2021. Yes. Subsequently, a petition was submitted to the Speaker of Parliament by some 7 members on a private members bill. Yes. And then there was, I mean, it went through the process. So if you can just remind viewers the events that led.
Started in 2021, as you mentioned. It was started by some private members in Parliament. So these members included the majority and the minority. You had people like Sam George, you had people like the MP for Adaklu, all of them coming in, including the Deputy Minister of Education at the time, who also joined this particular signature, puts in a signature to challenge, to send this bill before the Speaker. Yeah. The Speaker before that had already had concerns about the activities of LGBTQ activists, and he had met with a number of people where he raised concerns and actually indicated that they were going to look at a law to ban or to restrict or stop such actions, activities by such people. Not long after, this private members bill was sent to Parliament. When it was sent to Parliament, it was accepted by the Speaker. It went through the processes. People were invited to bring in their views. You had people, human rights concerns, which were brought before the committee dealing with this particular bill. You had institutions like SHRAJ going to having presentations before the committee. You had other interested parties who wanted to contribute to the formation of this bill. The Attorney General later came in. He also wrote an opinion, and in his opinion, he indicated that he felt or believed that this particular bill should come from the government. It should be sponsored by the government, based on certain concerns he had that there were some financial implications at the time per the bill when they looked at it or when it was under consideration at the time. And hence, once there were financial considerations, it should be sponsored by the government, not a private member's bill, because the private member cannot determine what financial obligations the government can have or take. So the Attorney General raised concerns about this thing. This bill went through the various processes. It was amended, had a number of times. There were even concerns about the number of years and punishment which should be meted out to people who are found guilty to have broken.
Even the name.
Yes, actually, even the name.
Because I think it started as the promotion of human rights, human sexual rights, and Ghanaian Family Values Bill.
Exactly.
Yeah.
Eventually ended up at the Human Sexual Rights and Family Values Bill 2024. So, I mean, it went through all these till it got to the day of passage. Don't forget that this particular bill started in 2021, as you mentioned. There were even concerns about the delay of the bill. Even allegations were made against the chairman of the Constitutional Legal Committee at the time, of Parliament at the time, the chairman of the time, that he was deliberately delaying the passage of the bill. So the bill had gone through different phases till 2024, February, where it was passed. Once it was passed, then there was this challenge. The challenge in court sent by Dr. Amanda Odoi and Dr. Richard Delaskai, a private legal practitioner. Their concerns were simple. For Richard Delaskai, his concern on this matter was that at the time of passage, Parliament did not have the requisite numbers to pass that particular bill. So they didn't have the quorum to pass that particular bill. And hence, he felt that that was against the Constitution, because the Constitution had given a quorum for passage, a quorum for sitting. Don't forget that recently, even with the issue of the majority-minority, who was majority-minority, the Speaker actually indicated and raised such concerns of having quorum to sit and quorum to take decisions. Richard Sky went to court indicating that the Parliament at the time of sitting to pass the bill did not have the quorum to pass or take decisions. Hence, he felt that the passage was unconstitutional. There was also the concern about the financial implications the bill had on the state, and the fact that per the Constitution, an individual or a private person cannot bring a financial burden onto the state. So that particular bill should be one promoted by the government. So these were the major concerns. Outside that, there were issues of human rights concerns.
And it's on the financial curve on which they sought the injunction to restrain Parliament.
Exactly. So they actually even argued on Article 108 of the Constitution, where they are saying that the Parliament breached that particular article by trying to bring a financial burden on Parliament, on the government, which is not coming from government. So these were some of the concerns.
I think this was the earlier position of the Attorney General as well.
This was the earlier position of Attorney General.
Because the bill also impacts or places a financial constraint on the government.
Exactly. A position which was held by Dr. Amanda Odoi. She is an academic and a human rights activist. She had concerns with this. So generally, this is what was sent to court. But at the time it was sent to court, Parliament was about to transmit that bill to the presidency for assent or otherwise. But what happened was that there was an injunction application as part of the suit to stop the transmission of the bill from Parliament to the presidency. This raised a lot of concerns amongst members or proponents of this bill, who felt like at the time it was a deliberate move to stop the president from even assenting the bill, looking at the pressure the public was putting on the presidency and government to sign. This bill seemed to have been popular amongst the general public. So there was a belief that once it goes to the president, the president would be forced to sign it. So there was the injunction application. The court had to now make a decision on that injunction application. What the court did was that it put on hold that injunction application and said that, look, we'll make a decision at the end of the hearing. So that injunction application was a bit moot at the time, because now you couldn't send the bill, and the bill too couldn't be signed. But today what happened? After a back and forth on this matter, the Speaker in Parliament having representations, arguments made by both sides, the Supreme Court finally came to the decision that this particular application or this particular suit did not hold water. Was at the time it was brought, there was no enactment. There's no law which the Supreme Court can stand on and overturn. So the Supreme Court dismissed the two suits.
But what my question here is it this reasoning, this thin reasoning, because it says that it will give proper reasoning to its decision by Friday. Is it applicable to both suits? Because there's one on constitutionality and there's one on human rights.
Exactly. It's applicable. The reasoning would be applicable to both suits. There will be two different reasonings from the court. It may be similar, but the court will provide two different reasonings for the two different suits. These are two different suits. This time, sometimes the court would consolidate it and make it one suit. But this time around, they didn't do that. They had the two cases differently and separately, and they decided that they were going to rule on it separately. So that's why you realize that the court called one, the Richard Sky case first, and called the second after it had given its decision on the Richard Sky case. So the reasoning, there will be two different reasoning, one on the Richard Sky case and one on the Dr. Amanda Odoi case.
So the Richard Sky case was seeking the court to declare the bill null and void.
Exactly.
Because according to the plaintiffs here, it breached some constitutional provisions.
Yes,
some provisions of the 1992
the Parliament did not have the requisite quorum to pass this particular bill. And Amanda Odoi's case was basically on the financial obligation they had to put on government. So these are the two separate cases. Even though they were all seeking the same thing, they all came into court with different issues, and the court is going to deal with the different issues. But now what is going to happen is that Parliament, now that the case has been dismissed, Parliament now has the power or the free will to transmit the bill to the president for assent. And it is now the prerogative of the president, after this bill has been transmitted, to either assent to it or decide not to assent to it. When the president doesn't assent to it or decides not to assent to it, what happens is that he has two options. He has to return to Parliament and tell Parliament that these are the reasons why I have decided not to assent to it. The other one is to refer it to the Council of State. And also give the Council of State the reasons for the Council of State to have a look at it and also see what they can do and can send back to Parliament for a decision to be taken. So now we are at a point of whether Parliament is going to transmit this bill now to the president. And if that bill, if the bill is transmitted now, whether the president will assent to it. There are concerns about the assent to this particular bill. Some people and watchers have said that this bill, when assented to, has some major implications for the country, especially when you are engaging the IMF, you're getting some interventions from the IMF,
the World Bank
and from the World Bank. You heard various people speak about why they believe that such people should be protected from foreign and international organizations. So now the concerns are whether when the president assents to it, are we still going to get the support we are getting from the IMF? Are we still going to get the support we are getting from foreign donors? These are some of the concerns people have raised. And there are concerns which other people also believe that, look, we shouldn't care about how they are going to support us. We should first think about ourselves and see whether this thing that has been brought or this thing that the foreign people are trying to get us to accept is good for us as a people. So people have asked the president to ignore the pressure from the international powers and think about what Ghanaians want and do what Ghanaians want. So this is where we've got into. The president has to make a decision whether to sign or not to sign.
And that will still be based on whether or not
Parliament
the bill
is going to transmit it
to the presidency or not. Thank you so much, Fred. I mean, so the news basically is that the Supreme Court has dismissed two cases or two suits challenging the constitutionality of the anti-LGBTQI bill. Now, under the provisions of the bill, those who take part in LGBTQ sexual activities could face imprisonment ranging from 6 months to 3 years. Now, the bill also imposes prison sentence of 3 to 5 years for the willful promotion, sponsorship, or support of LGBTQ plus activities. It has faced some opposition from various groupings, but has generally also gained support from a number of bodies, including some religious bodies in the country. We are waiting to see whether the transmission from Parliament to the presidency will happen and what decision the president will take subsequently. This is Channel 1 Television. My name is Nanatufo Boating. I did this with Fred Tate Japano. He is the head of current affairs production here at Channel 1 TV and on 97.3 City FM. Earlier you heard from Jude Mensah Duncan, who reported from the Supreme Court. We'll bring you more updates on this in our subsequent programming and news bulletins. Keep watching Channel 1 Television.